To order and ask everybody to join us, our council to join us in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And before we take the roll, I think we'd be remiss in not remembering the tragedy that happened out in Aurora this weekend. And I heard our guys did a great job out there. But let's take a moment of silence to remember those individuals for yet another mass shooting. Thank you. The roll, please.
Vaughn.
Here.
Shower.
Here.
McIver.
Here.
Marquez.
Here.
Kenny.
Here.
Clistic.
Here.
Belzak.
Here.
7 present.
We have a quorum. The next item on the agenda is the questions and comments of a general nature. We don't have anybody in the, well, we have Mr. Gustafson in the audience. Did you want to ask any questions? You're good, huh? Okay, there's nothing you need to know, or good. That's great to know. Do we have anybody up on the council that needs to make any comments? Yes.
Thank you, Madam Mayor. I received a question from Mr. Pearson on 8,000 block of Nantucket with regards to dogs barking, neighbors' dogs barking. What's the ordinance on neighbors' dogs barking late at night, say midnight, 2 a.m.? Is there anything that can be enforced, or how does that?
General disturbing the peace. Ed, you want to answer?
If they are having an issue like that, just give us a call. We'll send an officer out and document that that's happening. And then if the person wants to, we can always issue a citation for that.
Okay, thank you.
And Ed, if there's a citation issue, does the complainant need to get involved in
Normally,
terms
yes.
of? So they might have to actually sign the complaint. So there's a little more to it, unless maybe an officer is there at 4 a.m. and might hear the dog, or is there still you need the resident?
If it's something that they hear on their own, then they would issue a citation under their name.
Okay.
If it was a neighbor who was complaining and the person wanted to go to court over it, then the neighbor would have to come to court to testify what was happening.
So it's not just like a fine, right? You have to go to
If they just choose to pay a fine, that's all it is. They would just pay the citation
fine.
for it.
Okay.
Yeah.
But obviously, the resident would be given a warning first, which is
Yeah.
what we would normally do. And if
Okay.
they don't comply, that's when citations
ticket.
would be
Okay.
issued.
Right.
All right.
And that
So,
would be, again, they should call 911. They shouldn't.
Okay.
Some people are still hesitant on calling 911 for police service. They should just do that, and they would. That's the best way.
Okay. I can
Unless
reach out
you
myself.
take phone calls at 4 o'clock in the morning.
I try not to now.
Thank you. Any other comments? Yes, Alderman Yvonne.
I'd just like to make a few comments about what happened over the weekend with Sterigenics and Illinois EPA and his seal order and shutdown. We talked about this a few weeks ago at our last meeting about testing, and I just want to say that this was a result of the 30-day continuous testing that these results came out, and the Illinois EPA decided to take action. So I just wanted to formally thank Willowbrook for stepping up and taking the risk and doing their part and trying to make our residents safe. It's a huge concern for me because Ward 2 is my ward and Hinsdale South is in my ward, and we have so many kids and so many students and people that live in that area, 1 mile radius. So I just wanted to throw that out there that it was a result of the 30-day continuous testing. And as we do commence and go forward with our conversations about testing, I think it'd be a good idea for us to, what I mentioned last time was to coordinate with Willowbrook. I know they're in their final 16 days of testing. So if we can coordinate and somehow piggyback where they picked off and continue that testing and not wait 30 days and then start testing again. But I think it'll make our case a little bit stronger. And I'm not sure if Attorney Murphy, he can probably weigh in on this too as well. But I think it'll make our case a little bit stronger as we collect data and that we don't have gaps in that data, that we can actually see it 30 days. And then Hinsdale, I think Hinsdale Village, they're talking about this tonight, about doing testing. So if we can coordinate together, where we do our 30 days, Hinsdale, their 30 days, and we'll have 76 days of testing, continuous testing, just to build that case a little bit stronger. So I'm not sure how you guys feel about, well, I know how you guys feel, but I don't know how you guys feel about this presentation of it, of just continuing where they picked up, where they left off, and we kind of take the torch and help them out.
I think that we'll have Attorney Murphy give us an update on what's happening since Friday and what's going to be going forward with the courts getting involved today, over the weekend and today. So we'll have that to do. But are we going to be talking about what Alderman Vaughn is suggesting? I think we talked about before that we were going to wait for the EPA results coming out, and then we were going to do our testing, if I remember correctly.
Well, we had a proposal for testing, and there were some questions about those proposals. Should we, because the proposal we received was for everyday testing. And I think there was a question, Alderman Klistic might have asked, should we spread that out? Is 3 months doing a third of that testing better? And, but secondly, the city council asked that we include some items, some funds in the budget, which we'll talk a bit more about tomorrow. So there are funds included, but not specifically earmarked yet.
The idea is different, what you're suggesting. But, for Hinsdale, they're way too far away from our base. Yes, they can do their testing, but is it going to give us any idea of what's happening in town? I think we have to do our own testing.
Right.
But
I will talk to Willowbrook, and John would probably talk to their attorney about what is the best, in terms of the strategy for the continuing fight against stereogenics. But there might be a preference Willowbrook might have, or there might be something that they might say, well, it's better to have a gap. I don't know, but as soon as the council approves the funds, we can certainly, or before that, I could have conversations with Willowbrook and ask, in terms of how we're teaming up with them already, if how we could move forward with the testing, and if there's a best way to do that.
when I was talking to Mayor Triller this weekend, I got the impression that their testing is not ending now. They are going to be moving forward with additional testing.
Correct. So I think they have 16 more days that they're going to do testing,
You're
and
gonna
then
be past that.
and then no 16. I think 16 is
The impression I got
Yeah.
from the mayor was that it was going to be additional
okay.
past
So
that.
okay. So
But,
wherever,
we have
wherever
to
they leave off, we can pick up. I mean, it's just a concerted effort. I think where they have the units is right outside of their Willowbrook office there, the village.
They were
and because
a bit
that's
farther
where-
away too. I think they
Yeah.
had some at Gower too.
Yeah. So if we could, I mean, those could be potential sites for us as well, because we're all collecting. It's about collecting the data, right? So data is what's driving this whole thing. So that's where you receive most of the fugitive emissions right there in front. So if we could, get those planned sites, I guess we can use some of their sites and then we can have some of our sites as well. But I think it'd be important just to piggyback on where they're getting
Well,
some of
obviously,
their-
we'll be talking about this more tomorrow then.
Yeah, and I'm thinking back on the previous meeting too. The city council did want to discuss really what the action plan is and what is the best use of the money. I put money in the proposed budget without the specific plan yet,
Mhm.
because I think the city council wanted to determine what is the best way, to use those funds, and if it's testing, if it's other ways, and so that has not been determined yet. But I could check specifically with Willowbrook, and their panel of experts on, and again, and Attorney Murphy, to see if there is a best way to do that, do the testing.
It makes sense for us to piggyback with Willowbrook because we're right next to each other.
Right.
Lester, are you suggesting keeping the monitors where they are and just we pick up the tab going forward after their 16 days are out, so there's continuous data collection in those locations?
Correct.
Okay.
Yes.
That's
correct.
the impression I
Okay.
got too.
But I guess my question is, they tested at Hinsdale South. Have they gone any further west?
Eisenhower was another location.
Was
wasn't it?
Eisenhower located?
They were supposed to have Eisenhower, the
EPA's,
EPA,
yeah.
but
Not
when
Willowbrook.
I looked
No.
at the results on the website, I did not see any samples for there.
For Eisenhower.
for
Yeah,
Eisenhower.
me neither. Yeah, so that was one of the sites that
Mhm.
the EPA was going to use,
Yeah.
was
I
Eisenhower.
mean, we have Concord School, we have Mark DeLay.
Community Park.
Yeah.
Well, those were a few of the places
We
when
suggested.
we talked about our proposal that we're on for potential test sites.
Just a similar note, I was down in Springfield today with 3 trustees from Willowbrook, and on behalf of John Kern, we introduced 3 bills, 1852, 1853, and 1854. One bans fugitive emissions, one reopens the permit for Sterigenics, and I can't recall what the third one was, but there's 3 bills introduced today on the Senate floor in Springfield, so with regards to Sterigenics.
Okay, let's move on. Any other comments from the council? Let's move on to the approval of the minutes. Let's start with the city council minutes of January 21st. Do I have a motion to approve? Alderman Kenny, seconded by Alderman Vaughn. Any additions or deletions for those minutes? The roll, please.
Kenny,
Aye.
Vaughn,
Aye.
Shower,
Aye.
Marquez,
Aye.
Belzak,
Aye.
Clistic,
Aye.
MacIver,
Aye.
7 ayes.
The minutes of the January 21st minutes are approved. Now do I have a motion to approve the February 4th minutes? Alderman Marquez, seconded by Alderman Vaughn.
On a roll.
And on a roll. Any additions or deletions for these minutes? Then the roll, please.
Marquez,
Aye.
Vaughn,
Aye.
Shower,
Aye.
MacIver,
Abstain?
Kenny,
Aye.
Clistic,
Aye.
Belzak,
Aye.
6 ayes and 1 abstention.
The minutes of February 4th are approved. Let's move to receiving of communications. Do any of the aldermen have communications to share? And let's move on to the mayor's report. And I have nothing this evening, so let's move on to the city clerk's report.
No report this evening, Madam Mayor.
Let's move on to the city
No
administrator's
report either, Mayor.
Okay. Let's move on to the department head. We have Commander
I'm sorry,
Renka.
I'm sorry.
Yeah.
At what point did you want John to
He was going to
present?
do it under the treasurer's report.
John Murphy, I'm sorry.
I'm sorry.
I didn't know if he wanted to do it under our reports. He can probably go now.
You know
then.
what? Yeah,
Yeah.
that might be a good idea while we have the city administrator on. This is our city attorney, John Murphy. He's been involved with some of the activities, the actions we've taken to intervene in the case against Sterigenics, and there's been a lot of activity this weekend, starting with the seal order on Friday evening. John, do you want to cover what?
Yes, thank you. Let me take a couple of moments to kind of review the bidding of what's been going on in the litigation. Please recall that back in the fall, the Attorney General and the state's attorney filed the original lawsuit against Sterigenics in state court in Wheaton. Once that lawsuit was filed, both Willowbrook and Darien, our respective attorneys, we filed what's called petitions to intervene in the state court action, saying that we've got an interest in what's going on, and we have a voice to be heard, and we've got a right to be part of the case. The day that we were to present these motions in court, Sterigenics did a procedural device of what's called removing the case to federal court. Now, under the law, if a case is filed in state court and it presents questions of federal law, a party has the right to transfer that case to federal court. Sterigenics transferred the case to federal court just by filing paperwork to that effect. And their position in that was that even though this was filed by the Illinois Attorney General citing Illinois law, all of the underlying regulations, all of the underlying environmental requirements ultimately come from the Federal Environmental Protection Agency and federal regulations. Therefore, this is literally a federal case. The Attorney General and State's Attorney have opposed that by filing what's called a motion to remand. Basically, the state and State's Attorney are arguing, wait a minute, this is not a federal case. This is a state case involving state law issues. It belongs back in federal court. These are in state court, excuse me. Now, these are complicated procedural issues, and the parties have been briefing the matter. as a matter of strategy, because the state's attorney and attorney general are trying to get out of federal court, they asked us to hold off, us meaning Darien and Willowbrook, hold off on trying to intervene in the federal case because it would be inconsistent with what they're trying to do. In other words, if the state's saying, we want to get out of federal court, it would be inconsistent with that to have the two municipalities saying, hey, we want to get in the case for the purpose of getting out. So we abided by that direction. During the day of last Friday, the 15th, the federal judge to whom that case is assigned, Judge Lee, issued an order asking for more legal briefs by the state and Sterigenics on this issue of does this belong in federal court. So you can kind of see up to that point, it was in kind of a procedural morass that the judge had to sort out whether he's going to keep the case in federal court or send it back to Wheaton. Later in the day, of course, the IEPA director issued an emergency seal order, which I think you've seen, which was done as an administrative matter, saying that we've determined that an emergency exists and we're ordering the ethylene oxide containers on the premises of Sterigenics to be sealed. Tuesday, so that was Friday late in the day. Tuesday, Sterigenics filed a new lawsuit in federal court, asking on an emergency basis that the seal order be overturned and to allow them to go back into business. Now, that was filed this morning. It was assigned to a different federal judge, Judge Kennelly. The matter has been set for hearing on the temporary restraining order for tomorrow at 11 o'clock, and I'll be there. Ordinarily, when there's a motion for what's called TRO, I think everybody's heard that term, which is a very short-term order designed to maintain the status quo, the judge doesn't engage in fact-finding, like a trial or listening to witnesses. Ordinarily, what the judge does, because the effect of that order is just for a week or two. Ordinarily, what the judge will do is listen to arguments of the lawyers and decide just on the face of the documents, the complaint, and motion for relief filed by Sterigenics, whether the judge should lift the seal order for a short period of time and schedule it for further proceedings. So the potential options tomorrow is, first of all, I dislike handicapping results of court, what can happen. If the judge rules for Sterigenics, the plant reopens for a short term, and the seal order from the state is, to use a legal term, kiboshed, okay, is blocked. The judge could say that, no, at least on the short term, we're going to keep the emergency order in effect, but we'll schedule this for further hearings, which would involve fact-finding, testimony by experts, and the like. Another possibility is that Judge Kennelly, who's got this case, may take a short-term action, but say, wait a minute, this case belongs with Judge Lee, the judge with whom this case was filed originally. I'm the emergency judge, but I've taken a look at that. I think the judge who's assigned to the case should make the determination on this one. So there's a multitude of options and that may occur, and so we'll be there as observers tomorrow at 11 o'clock. As I mentioned before, I do not think that at that time there's going to be witness testimony. It's in this setting, it's almost always on the papers and attorney argument. So we'll report back to the council as soon as we hear what happens in federal court.
John, if he decides to keep the seal order and they go to fact-finding, the data would shows the levels throughout the neighborhoods, and that would be part of the fact-finding.
Yes, that would be part of it. Now, remember, evidence requires witnesses. There'll have to be witnesses to lay a foundation for the data, introduce it, and advise the judge, and testify as the import of the data. So but I do not expect that fact-finding to be tomorrow.
John, when you said he may send it back, Judge Cannelli may send it back to Lee, will he have to make a determination of yes or no, deny the TRO or approve it before he sends it to Lee?
He could do
Or
both.
does he defer it?
He could do both if he says, I accept Sterigenics' arguments that the director had no basis to shut Sterigenics down. He could say, I'm going to restrain the state from the shutdown order for a period of a week, 2 weeks, but I still think this case belongs in front of the other judge because the other judge has got the original lawsuit. That's a possibility.
John, because of what their company is supposed to be sterilizing, could they say it's a sense of emergency to the community because they're
That's what they're saying.
That is exactly what they're saying. They say part of I'm not telling any stories out of school because these are all public records.
Right.
So Sterigenics' argument for this TRO is twofold or threefold. First, the emergency is that they supply surgical equipment in large volumes to a large number of hospitals, and that to lose this part of the supply chain can literally be a matter of life and death. Part two of the Sterigenics claim for this emergency relief is that, in simplest terms, wait a minute. The Attorney General filed this lawsuit, 3 months ago, October? And the Attorney General didn't ask for any sort of emergency relief. And therefore, this is an improper attempt to use an emergency provision in the Environmental Protection Act to do something that they should have been trying to do in the original case. Follow? And of course, there's new data that the Attorney General will respond to that. But and the third one is what I'm referring to as good old-fashioned due process, meaning just like we can't close a tavern, a liquor license, without some form of pre-termination hearing, you shouldn't be able to shut down a multi-million-dollar business, which in their mind is operating in compliance with all of the permitting requirements of EPA without at least giving them a hearing. So that's kind of a summary of what Sterigenics is saying. Naturally, with this thing being filed this morning, mid-morning, the state hasn't had an opportunity to respond to that. They'll be doing that tomorrow morning and then during the hearing late in the morning. So it's a procedural jungle at this point, but if there's one, I guess, good thing for the communities is that the combatants are finally in the ring, which is something that everybody's been asking for in different forms for months. Now we've got the people with the authority and the business in the same venue and poised to fight this thing on the merits now, which I think may end up being a good thing for everybody.
John, would this case be subject to remand also? I mean, what's the federal issue in the new case? If they're alleging that it's the IEPA is saying they're a violation of Illinois law, not federal law, I assume.
They're alleging their hook to get in federal court, Tom, on this case, on case 2, is due process. Like just as if we shut down a liquor licensee without giving what's called a pre-deprivation hearing, we would violate their federal constitutional rights to due process. That's their hook. They're saying that their right to operate continuously is a valuable property right, and it should not be deprived by the state without what's called pre-deprivation due process. That's their federal hook.
Okay.
I should note that, and probably something that the state will respond to, is that if the director issues an emergency seal order, that same statute provides a right to a hearing on that. Might be called post-deprivation due process. So that may be one of the battlegrounds.
And if a TRO does get granted, when are we looking at a permanent injunction hearing?
They'd probably be looking at a preliminary, that'll be up to the discretion of the judge, because Sterigenics is going to say, wait a minute, we need to take 9 depositions before a preliminary injunction hearing, because if they've got to stay, that's to their advantage. So the state naturally will now argue that we want a quick hearing.
And I'm not familiar with federal laws that much. Is there a time frame on a TRO?
10 days.
It's 10 days.
Yeah.
So can I ask a quick question that comes up with many residents? So, for example, back to your tavern, if that tavern is a nuisance to the community, a lot of people are, I don't know, doing stuff afterwards, people can't sleep, is reducing property values. I've seen in Willowbrook ordinances that businesses that reduce property values that are a detriment to the community can be shut down, not even looking at any of the pollution, but the effect of property values and traffic in the area. Why wouldn't they have the power to do so through that angle? Not looking at the pollution, but just how badly it's affected the community from the press, from the property values. Why wouldn't they be able
Well, that's
to
a
address it?
possibility, but those involve facts. And let me go back to my original point, that at this very beginning stage of Federal Suit 2, ordinarily the judge acts just on the face of the complaint without fact finding. It could ultimately, Tom, end up that way. My example of the tavern or the liquor licensee, there's a provision in the state law that provides for an emergency shutdown order that can go no more than a week. Now, of course, when you're dealing with environmental challenges, it's a world of difference between that and a noisy bar.
But if you left the environmental challenges out and just look at how they affected the area with regards, for example, traffic, how they've been reducing property values in the area. So just leave the whole environmental thing out and look at the other ways it's been affecting the city of Willowbrook. So that makes it, to me, clear they're bringing all of the other question marks into it as well.
That sort of case, I talk about almost like a non-environmental case. That would require a great deal of fact-finding. I mean, if you think about it, I always have a saying that, lawyers don't win cases, witnesses win cases. So that both sides would have the right to marshal their facts, present their witnesses, give depositions and the like. That becomes more in the nature of a land use case as opposed to an environmental case, and land use cases take time. So I think the focus is going to continue to be on the environmental aspect, especially the way this thing has moved suddenly so fast.
Okay.
A shutdown order at 4 o'clock on Friday, a lawsuit trying to overturn the shutdown order Tuesday morning. That's pretty quick.
Any other questions?
John, as a follow-up to Tom's question, if a community were to go that route on some business and shuts it down, they would appeal to the courts. I mean, that's typically what happens.
Oh, sure, yeah.
I mean, if a community took that action against any business.
Right, yeah, I don't want to, because I think this is first and foremost an environmental matter that needs to be resolved. But from the nuisance standpoint, people are, property owners are entitled to a hearing before the property is discontinued. We've talked about that with the massage parlors. The difference is, massage parlors don't cause cancer, and environmental problems do. So I think that I think that the state will continue to keep the focus on the environmental. That's not to discount the land use, the impact issues, which I think, Tom, is what you're talking about, that the impact of the controversy makes it such that I certainly wouldn't want to be somebody who lives in Willowbrook and I'd get transferred to Austin, Texas, trying to sell that house. I mean, those are some of the real human problems.
Gotcha. So it's sort of the image it portrays that they're scared to go after them because they're really big, but if it was a small local business doing something erroneous and reducing property values, the city would go after them. So that's why they sort of see that double standard that they're able to fund maybe more than maybe a parlor or massage parlor, whatever the case may be, would able not to defend as much as in court. So that's, I think, what sometimes maybe the opinion or view residents might.
Well, now that the swords are drawn
Yes.
on the environmental issue by both sides on a more of an emergency basis, I don't think there's any turning back now.
So it wouldn't go off into other
tangents, okay.
areas then?
I don't think so. I mean,
It'll
it's
stay
not-
in the environmental, yes.
it's not that those issues are dead. It's just that now the environmental problems are front and center, and are going to have to be addressed by both sides on the merits sooner rather than later. Naturally,
Okay, let's,
I'm sorry, Tom, I know you had another question. I was just explaining to Mayor Weaver. You had
even though we're
asked
talking, I
about-
just want to make one point for the council and the audience. Even though we're talking about pending litigation, and everything right now is in the open, and I think it's important that everybody
yeah,
hear it.
yeah.
Tom, you had also a question in the RCRA Act.
Correct. So that was
This
just.
is probably a good time.
Oh, okay, yeah.
Yeah.
So there was doing some research. There was a case in New Jersey where the EPA had failed to act, and the city or the residents went together and sued the EPA for not acting on enforcing some laws. So I'm just wondering if that would be something you could do, if something didn't work out. But if that's, how does that work? That law, just a general top level.
I think that what you're describing, I'm not familiar with that case, but it may be an effort to force the agency to act. Here,
They've acted.
now they're acting.
Yeah.
Yeah, I did take a quick look at that, and that's exactly what it was.
It was like
Yeah.
what we call, mandamus, essentially, which is ordering a governmental body to do something. Not that the residents would pick up the gauntlet themselves, but it's to direct the agency to do what they should be doing. But now we're there.
So, yep.
Alderman Belzer, you're saying you looked at the RCI?
The case that he referred to, and when he sent that out, I pulled it and looked at it, and it was exactly about the citizens getting the agency to do what they were supposed to be doing in the first place.
Okay, all righty.
Now, another possibility, becomes kind of a Rubik's Cube on Law Procedure 101, is that the original judge hearing the case, Judge Lee, could agree with the state and say, you know what, this isn't a federal case. Back you go to DuPage County, even while the other thing is pending, Tom, to go to your point. So that's a possibility, in which case, if it goes back to DuPage County on the ruling that this is state law, state regulations, a state court matter, then our petitions, the petition that we filed on behalf of Darien and the petition that the corresponding petition that the Willowbrook lawyers filed will be back in front of Judge Fullerton, who's got the DuPage case, and it's on hold. So that, that's also a possibility.
But you just said the TRO and what Sterigenics has filed could still be staying at the federal level, even though Judge Lee sends it back to the state level.
Yeah, yes, the lawsuit 2 could stay in federal court, while lawsuit 1 could be pitched back to state court.
Would maybe conflicting.
They wouldn't be conflicting because they're technically different issues. It's that the federal Constitution prohibits the state from destroying somebody's property interest without a pre-deprivation hearing. The essence of lawsuit 2 is that the state shut down this business without a prior hearing. And especially in light of the fact that the thing's been pending for 3 months and all of a sudden, a shutdown order when they could have brought an emergency order in front of the judge. So it's possible that lawsuit 2 stays and lawsuit 1 goes back to state court, but it's really a stew at this point.
Judge McGoran.
Yeah, John, I'm not trying to diminish this, but early on in the process, I thought I heard that they had a permit that they were allowed to do this until sometime in 2020. Is that true? And if that's true, does that mean that a year from now or in approximately that time, that the problem would at least stop at that point, even regardless?
Well, their permit is till, I thought it was till 2023.
2020, April.
Was it April 2020?
Yeah.
But that's before the federal EPA, and they could allow them to, and re-permit them. Or
Hopefully not at that
or
point,
not,
at least.
yes.
So
Yes, or not.
So at least-
yes.
So, but we've got all of 2019 to deal with. So.
Mayor, I'm sorry, one question. John, there's been talk now about, at the state level, new laws to address this that would not allow the ethylene oxide. What happens on a law in the state? Obviously the state gets sued all the time also. So they might come up with a law. That doesn't mean it ends there. Maybe so we understand, what's happening at the state level should a new law be adopted.
Yeah, that happens all the time. If the state adopts a regulation prohibiting, the use of this chemical in certain operations, the industry could bring a lawsuit challenging that. No different than if the state passes a law restricting gun owners' activities. Gun groups could challenge the law, so it's never immune from challenge. Any kind of a regulatory law is always subject to a potential challenge by an individual business, by a trade group, by the industry as a whole. And you can imagine on a pre-passage basis, there'll be intense lobbying by both sides. This is obviously a huge business, huge industry.
I just want everybody to understand the state law is not the end of it either. Possible.
Yeah, you never,
Don't know.
that's when I say it's a
What do you
Rubik's,
want to say? Call it
Rubik's Cube's of
Cube.
possibilities.
Yes. Any other questions for John? I know there's a lot to mull over.
Will we find out anything then tomorrow?
As soon as we find out
As soon as
something,
I find out,
we'll post it on Direct Connect, the results. Well, hopefully we'll have an answer tomorrow.
I don't have an appearance on file, meaning I don't have the ability to stand up on the case, but I'll be there, and I'll let the AG know. I think the Willowbrook lawyer will be down there too, that we're here, and maybe they can sneak that in as well.
Okay. Thanks, John.
All righty. Lots to chew on. All righty, let's move to department head information. Chief Commander Renka, did you have a report that you wanted to address this evening?
No, I do not.
Any questions for Commander Renka? No. Okay, all right. How about for Director Gombeck? Yes.
I've been asked by several residents about that new material that we're using on the streets. They've been seeing the stripes and they keep asking me, what is that? Just wondering again, as long as we're on TV, if you can just briefly go over that, satisfy their curiosity.
What you're seeing there is it's a product that's referred to as GeoMelt, and what that does is it's an anti-icing product. It's a liquid form. And prior to a storm event or prior to a predicted storm event, and depending on what the temperatures are, the guys will go out there and they'll basically put this on the road prior to the storm. All the roads that we're doing are basically the primary roads at this point. And what it does at the end of the day, it's when it starts to snow, it buys the crews, if you want to say, several hours, and also provides a safety to motorists that once it starts snowing, that snow doesn't stick to the road right away, it begins to melt it. So it gives everybody an opportunity to be safer, and it gives us an opportunity to get out there and now use the product, use salt right away.
Does it make the salt more effective also? I know salt usually only works to a certain temperature. Does it affect that and maybe make
There's a
it?
different product we use that we blend with the salt for colder temperatures. The product that you see is independent of the salt itself. It does reduce the salt usage by applying this liquid. We don't have to be out there as quick in putting down the salt.
Okay, thank you.
And I think it's also more environmentally friendly.
Oh, definitely.
It's
Yes,
made
all
from
the
beet
products are.
juice.
Beet juice.
Yeah, I think you brought that up when you first told us about it.
Mm-hmm.
Yeah, they are agricultural products, some byproducts in there, but overall they are environmentally friendly. Yes.
And I think they're better for your car too, like they're non-corrosive, so. it
Correct,
doesn't have
streams,
the-
rivers, and where the salt really ends up at.
Do any of our neighboring municipalities using the same product?
I'm not aware of Willowbrook. I believe that Burr Ridge has started to use it.
I think I saw it in Hinsdale as well.
There was on the Channel 7 News last week, there was a whole story about Arlington Heights and some northwest suburbs that are using the same product on their street.
Yeah, and the products have been around for a number of years. The problem always has been, which product is really worth using and what is the longevity of the product to be, the life of the product on the road. Years ago, when I looked at this, probably close to 5-7 years ago, there was definitely no return on investment. We're starting to see a return on investment. But at the same time, this has been an anomaly of a year where we've had rains. So, we've had more rain than we've had snow, and the temperatures have dropped after the snow events, in which case we use the other products. So it's difficult at best to determine, what the benefit was this year, but it has been a benefit. I think we'll need 2 years to put that report together.
And since we're on the topic, you got an email from Mr. Nemec that I was CC'd about it. I know Chris went out and he's on the Darien side,
Correct.
and unfortunately, unincorporated Downers Grove Township plows his street, and he can't benefit from that. Is there anything we can do? And I'm
going to take a look at that with Chris tomorrow. I understand the subject. When does township get out there? Township seems to be, their services are quite slower than ours are, put it best.
To be nice.
So,
well, they got more to cover. I'll cut him that, right?
so it's, we're there first already. And it's no different than us going down a roadway. Some of our residents are in unincorporated blocks. We just don't pick the plow up.
Right.
Because it's Downers Grove Township. There's some reciprocation there. Whether we get there first or Township gets there first, we'll plow it.
Okay.
But
What was Mr. Nemec's comments? Was it that it
Dave,
wasn't done well?
The
Steel melt?
the history doesn't see it.
Oh, he doesn't see it because it's not down on his street, because he's split between Downers Grove Township and
Right.
Darien.
He's not a primary street.
Yeah,
at
it's
the
not
same
on every
time.
street, it's just the main arteries.
Right.
This
Okay.
is something that we could expand, but I don't think to expand it to the secondary roadways is something that's beneficial at this point.
Okay. Any other questions for staff? Alderman Clistic.
Thank you, Madam Mayor. Just a quick one. How are we on salt this year? Above budget, below budget? Hopefully.
Thanks, yeah, I was just going to
Below.
bring that up. We will be over on salt this year, and if I'm
What does that mean, over?
I'm just getting there. Dollar-wise, we're probably going to be close to $75,000 over on salt. The problem has been these ice storms have just been ridiculous. We go out within 45 minutes, the salt is washed away, and the ice reforms again. So we've had more frequencies this year of these ice events. But we'll have something together here within the next couple of days as well. But I am
And more ice events.
We will be over, Tonight's,
Yeah. Is it
tomorrow
big
morning,
question?
ice events, yes.
Yeah.
With budget coming up, maybe we have to look at that, right?
Well, we're gonna come back to the city council through a resolution, for MFT funding on that portion of it. So that won't be presented till May, closer towards probably April.
Because we're what, 16, is what they're saying, we're 16 inches over the norm. Usually it's about 26 inches of snow we get in a season, and we're at 41.
While we're over, it's the frequencies also that have a major effect on us this year. Because you can't measure the rain
Right.
events.
Okay, let's move on to the treasurer's report.
Thank you, Madam Mayor. This evening, I'm requesting council's approval of warrant number 181920 in the amount of $970,335.54 from the listed funds. Payroll for the period ended February 14th in the amount of $260,118.13 for a total to be approved of $1,230,453.67.
Do I have a motion to approve? Alderman Belzak, seconded by Alderman Shower. Discussion? Roll, please.
Belzak.
Aye.
Shower.
Aye.
Vaughn.
Aye.
Marquez.
Aye.
Clistic.
Aye.
McIver.
Aye.
Kenny.
Aye.
7 ayes.
The warrant has been approved. Do you want to go over the monthly report?
The monthly report for the 9 months through January 31st, 2019 reflects general fund year-to-date revenue of $12,606,309, expenses of $10,347,157, current balance of $3,464,102, water fund year-to-date revenue of $6,662,552, expenses of $4,389,937, current balance of $3,303,240. Motor fuel tax fund year-to-date revenue of $434,370, expenditures of $270,231, current balance of $553,577. Water depreciation fund year-to-date revenue of $3,458,922, expenditures of $1,400,677, current balance of $2,172,288, and capital improvement fund year-to-date revenue of $240,207, expenditures of $3,940,689, current balance of $5,421,564.
Any questions for the treasurer on the monthly report? Well, he'd like to take time to go over the police pension report that he has this evening.
As I mentioned at last meeting, we were going to have our meeting of the quarterly meeting of the Darien Police Pension Fund. This was for the quarter October through December 31st of 2018. As you'll recall, we have 2 outside investment managers that each manage approximately $13 to $14 million in assets for the total in the fund of approximately $27 million. Their performance was almost exactly the same, unfortunately, for the quarter. As you might recall, the stock markets started going negative about October, mid-October, and really accelerated into December. December was the worst December since the Great Depression. Consequently, I wasn't anticipating very good numbers, I think, as I told you last meeting. And the real numbers for the quarter, the one investment manager was a deficit of 7.19% for the quarter. The other one was 7.38% for the quarter, so almost exactly right on. For the year-to-date, which is 12 months, they do it on the 12 months, so theirs is on the calendar year basis. They were each at a deficit for the year of 4.52% and 4.66%. With the first quarter last year, which we still have this year's first quarter to make up, showed a deficit of roughly 0.5%. So if you take that out, currently at the end of December, we were approximately a negative 4% as of the end of December, whereas the anticipated rate of return for the fund is 7%. So you can see we're 11% behind. The only good news that there is as bad as that quarter was, January and so far February have been really outstanding. Probably one of the best Januaries we've had in a long time, where the overall markets have been up about 10%, although our equity mix is only about 55%, so we won't be participating completely in that. And February it's been up again, so if that stays consistent, I'm hoping we could at least get closer to that 7%, although I can't imagine getting to that 7% return by April, which means we'd have a deficit, which again would just result in an additional increase in our contributions into the police pension fund. But was a pretty disastrous quarter. But again, fortunately, January and February seem to be improving. So looking forward to better numbers in the next quarter. But
Any questions for Treasurer Corr on that, the report? Yes, we can all hope for that be better. Thank you. Let's move to Standing committee reports. Do the chairman have reports to share? Alderman Marquez?
Thank you, Madam Mayor. Municipal Services will be meeting next Monday night, February 25th, here at 6:30 in the council chambers.
Alderman MacGyver?
Thank you, Madam Mayor. The next meeting of the Darien Police Committee is scheduled for Monday, March 18th, 2019 at 6 p.m., pending agenda items in the Police Department Training Room.
Thank you. Alderman Shower?
Thank you, Madam Mayor. Our next admin finance meeting will be held on Monday, March 4th at 6 p.m. in our upstairs meeting room. And our first budget meeting, Committee of the Whole, is tomorrow night at 6:30 p.m. in council chambers.
Thank you. And we'll all be here. Be here or square, be there or be square.
Be square, you got it.
Okay.
Since our days.
Okay, let's move to questions, comments, agenda related. Any questions? We have 2 items on the consent agenda. Alderman Klistic, I think you had an issue over the sickage being on the consent. Did you want to remove that?
Yeah, we just didn't have a quorum, so I just thought it'd be on new business because generally if it's passed.
Both items will move to new business. We will
Okay,
not have a
that's,
consent agenda.
Okay.
Yeah, one item cannot be on a consent agenda. So, all right, so we'll move both items to new business this evening. And any other comments about tonight's items? Then let's move to old business, and there being no old business, we'll move, and no consent agenda. We'll move to item A under new business, which is a motion to approve the acceptance of a 4-year proposal for auditing services from Sikich. Do I have a motion to approve? Alderman Kenny, second by Alderman Shower. Discussion.
Last week, for the last administrative finance meeting, myself and Alderman Klistic were there as a reminder, so there was no quorum. That's why this is on new business tonight. But during the council meeting, Alderman Corn had discussed, the ins and outs of, our relationship with Sikich, and I think he answered a lot of our questions at the last meeting. So I know I'm good with it.
Alderman Klistic?
Yeah, the only comment I got from one of the residents was that they missed the cell phone tower issue last time, so why are we having them again? And I think we discussed last time how that got missed, because it's not something we invoiced to the cell phone tower company or to AT&T, whoever has that contract. So I guess the question is, what are they doing now to making sure that doesn't get missed or something similar won't get missed?
Well, I think it's like any other job. I mean, there's no guarantees. I mean, they set their audit standards, they set their testing to try and test various items. Yeah, we weren't happy about the fact that it was missed. Fortunately, it was caught. Are we missing something else? We could be. Are we doing a lot of things right? I think we are. Some people say, should we change auditors just to get some different approach to it? I guess I'd throw it back at you and say, do you think your boss should fire you just to get a fresh approach to your job? I'm not a fan of that type of thing either, because we have had a good relationship with them. They've done a lot for us. I think we've had this relationship. We've been interacting with them for quite some time. They've had the right to bill us for extra services. They've never done that. 2 years ago now, Marie quit and Julie came on board just as we were ending our fiscal year and just at the start of the audit. So there was a lot of hand-holding involved. They didn't complain. They didn't charge us, again, they didn't charge us anything extra for the additional services. So, I mean, I think we've had a good working relationship with them. We've gone out for bids, submitted requested quotes from 8 firms. Only 2 of them submitted it. And Sikich, who is a firm we've known and worked with and has a lot of resources, I believe, in the municipal area, actually came in with the lowest bid, in addition to being somebody that we've been dealing with. And, I had one other minor issue with them that I called to the partners' attention last year, and immediately the next day it was addressed. So, I mean, I've had a good relationship with them. If any of you see anything, I'm happy to listen, but from my standpoint, I highly recommend them.
Okay. I mean, the question is, if they're an auditor, so their job is to catch secondary stuff, and the cell thing, they didn't catch, so that's what the resident was upset about. So why would you bring them back in?
If you read the audit opinion, the audit opinion is that the financial statements are in compliance with generally accepted accounting principles. It's not to catch every mistake. If it was to catch every mistake, I can guarantee there'd be more than just that one. I mean, a lot of us, staff goes through a lot of things. I come in and review things. I catch things even after having gone through several levels of review. I'm sure if you reviewed even the things that I've reviewed, there's a small chance, but there's still a chance that maybe I've missed something over the course of these 12 years. But there is a
No,
chance.
you're right. I mean, if you're like, you're missing $5 to 10, that's fine. But it's, to resident, I sort of have to agree. It's like a whole thing of $50,000 a year that was missed, right? So that's something big. That wasn't that it was $10 and 15. This was sort of big, So the resident was okay. We're bringing the same guys back in again. So
Do you have only one resident with that?
only one that was watching the
and
movie.
you got
yeah.
probably about 4,000 residents in your ward, maybe 5,000. Yeah, I think we're good.
So far, we're good.
I mean, just on top of that, with Sickich, we also every year have different set of people come in with a new set of eyes. So it's never just the same auditor every year.
Right, yeah.
And the key of this whole thing, when it gets right down to it, is we have an audit group in Sickich that basically has a different set of eyes, and they're catching, if they're going to catch something, they're, one set of eyes is going to catch it one year, not the next year. And we're not going to have a situation that was happening in Dixon, and that's the big thing and the big question that goes with it. So,
And they do have a lot of resources. They've rotated partners, they rotate staff, so they have the ability. The other firm is smaller. They don't have nearly the resources that Sickich has, in my mind. So, again, my recommendation is that we stick with them, but it's your vote.
You spent most of your time with them more than we do, so I think we're there.
Any other comments on item A? Then let's have the roll, please.
Kenny,
Aye.
Shower,
aye.
Vaughn,
Aye.
Belzak,
Aye.
Clistic,
Aye.
Marquez,
Aye.
MacGyver,
Aye.
7 ayes.
The motion has been approved. The next item, item B, is motion to approve the recommendation to release the executive session minutes that no longer require confidentiality. Do I have a motion to approve? Alderman MacGyver, seconded by Alderman Marquez. Discussion? The roll, please.
MacGyver,
Aye.
Marquez,
Aye.
Kenny,
Aye.
Clistic,
Aye.
Belzak,
Aye.
Shower,
Aye.
Vaughn,
Aye.
7 ayes.
The motion has been approved. Let's move to questions, comments, and announcements of a general nature. Any of the aldermen have anything to share? Alderman Marquez?
As I was watching the whole thing in Aurora unfolding, I guess what really hit me was that the response time of the police to that incident probably saved a number of lives. Those guys were there right away. They got in the building right away, and they put their lives on the line for that. And I think all of us are grateful for that. It reminded me that our police here in Darien would do the same thing. And I think that we don't oftentimes give our first responders all the credit. I think we do, but I think the public needs to understand that we've got a pretty great police department here in Darien that I think would do the same thing. So a credit to the guys who did that in Aurora, but thanks to our guys as well for putting their lives on the line every day. And hopefully we will never have anything like that in Darien.
Commander Rentke, how many of our team went out there?
One, there's a call out, mutual aid call out, and each level of the call out will send 5 officers. So if they have a level 3 call out, it would be 15. Just keeps multiplying by that. So we had 1, and if they needed more, then we would have sent more.
Was that a member of our already made up SWAT team that went out there?
No, he's not. He was our former K-9 officer, though.
Okay, all right, so that's who went out there. So one of our officers, and I at church on Sunday, one of the residents came up to me to tell me that they saw our guy on television when they were watching the ordeal. So kudos to our police officer who was involved. Any other comments? We were thinking about doing an executive session. I don't think we need to do that, so I'd like to ask for a motion to adjourn. Alderman MacGyver, seconded by Alderman Vaughn. All in favor?
Aye.
Hey, Brian.